Chapter 7 Fundamental Rights. The fundamental rights are enshrined in Part 3rd of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA, that is, Bill of Rights. Part 3rd of the Constitution is rightly described as the Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. The fundamental rights are guaranteed by the Constitution to all the persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest, and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not a man. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are fundamental also in the sense that they are most essential for the all round development, material, intellectual, moral, and spiritual of the individuals. Originally, the Constitution provided for 7 fundamental rights, that is, number 1, right to equality under Article 14 to 18, number 2, right to freedom under Article 19 to 22, number 3, right against exploitation under Article 23 to 24, number 4, right to freedom of religion, Article 25 to 28, number 5, cultural and educational rights, Article 29 to 30, right to property, Article 31, right to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act in 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of fundamental rights. The fundamental rights guaranteed by the Constitution are characterized by the following. Number 1. Some of them are available only to the citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporations or companies. Number 2. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. Number 3. All of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. Number 4. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. Number 5. They are justiciable, allowing persons to move the courts for their enforcement if and when they are violated. Number 6. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of High Court. Number 7. They are not sacrosanct or permanent. The Parliament can curtail or repeal them, but only by a Constitutional Amendment Act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. Number 8. They can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression, external emergency, and not on the ground of armed rebellion, that is internal emergency. Number 9. Their scope of operation is limited by Article 31A, saving of laws, providing for acquisition of estates, etc. Article 31B, validation of certain acts and regulations included in the 9th schedule, and Article 31C, saving of laws giving effect to certain directive principles. Number 10. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous services can be restricted or abrogated by the Parliament, Article 33. Number 11. Their application can be restricted while martial law is in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order under Article 34. It is different from the imposition of national emergency. Number 12. Most of them are directly enforceable, self executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the parliament and not by state legislature so that uniformity throughout the country is maintained under Article 35. Definition of a state. The term state has been used in different provisions concerning the fundamental rights. Hence, Article 12 has defined the term for the purpose of Part 3rd. According to it, state includes the following. Number 1. Government and Parliament of India, that is executive and legislative organ of the Union Government. Number 2. Government and legislature of a state, that is executive and legislative organ of the state government. Number 3. All local authority, that is municipalities, panchayats, district board, improvement trust, etc. Number 4. All other authorities, that is statutory or non-statutory authority like LIC, ONGC, SAIL, etc. Thus, state has been defined in a wider sense so as to include all its agencies. It is the action of these agencies that can be challenged in the courts or violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. Laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental right shall be void. In other words, it expressively provides for the doctrine of judicial review. This power has been conferred on the Supreme Court under Article 32 and the High Courts under Article 226 that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following. Number 1. Permanent laws enacted by the Parliament or the state legislature. Number 2. Temporary laws like ordinances issued by the President or the state governors. Number 3. Statutory instruments in the nature of delegated legislation, executive legislation like order, bylaw, rule, regulation, or notification. Number 4. Non-legislative sources of law, that is, custom or uses having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right and hence can be declared as void. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Keshwanand Bharti case of 1973 that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence can be declared as void. Table number 7.1, Fundamental Right at a Glance. Number 1. Right to equality, Article 14 to 18. It consists of equality before law and equal protection of law under Article 14. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth under Article 15. Equality of opportunity in matters of public employment under Article 16. Abolition of untouchability and prohibition of its practice under Article 17. Abolition of titles except military and academic, Articles 18. Number 2. Right to freedom under Article 19 to 22. It consists of protection of 6 rights regarding freedom of speech and expression, assembly, association, movement, residence or profession under Article 19. Protection in respect of conviction for offences under Article 20. Protection of life and personal liberty under Article 21. Right to elementary education under Article 21A. Protection against arrest and detention in certain cases under Article 22. Number 3. Right against exploitation under Article 23 to 24. Prohibition of traffic in human being and forced labor under Article 23. Prohibition of employment of children in factories under Article 24. Number 4. Right to freedom of religion under Article 25 to 28. Freedom of conscience and free profession, practice and propagation of religion under Article 25. freedom to manage religious affairs under Article 26, freedom from payment of taxes for promotion of any religion under Article 27, freedom from attending religious instruction or worship in certain educational institution, Article 28. Number 5. Cultural and educational rights under Article 29 and 30. Protection of language, script and culture of minorities under Article 29. Right of minorities to establish and administer educational institutions under Article 30. Number 6. Right to constitutional remedies, Article 32. Right to move the Supreme Court for the enforcement of fundamental rights, including the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto under Article 32. Table number 7.2. Fundamental rights of foreigners. Fundamental right available only to citizens and not to foreigners. Number 1. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth under Article 15. Number 2. Equality of opportunity in matters of public employment under Article 16. Number 3. Protection of 6 rights regarding freedom of speech and expression, assembly, association, movement, residence, and profession under Article 19. Number 4. Protection of life and personal liberty under Article 21. Number 5. Right of minorities to establish and administer educational institutions under Article 30. Fundamental rights available to both citizen and foreigners except enemy aliens. Number 1. Equality before law and equal protection of laws under Article 14. Number 2. Protection in respect of conviction for offences under Article 20. Number 3. Protection of life and personal liberty under Article 21. Number 4. Right to elementary education under Article 21A. Number 5. Protection against arrest and detention in certain cases under Article 22. Number 6. Prohibition of traffic in human beings and forced labor under Article 23. Number 7. Prohibition of employment of children in factories under Article 24. Number 8. Freedom of conscience and free profession, practice and propagation of religion under Article 25. Number 9. Freedom to manage religious affairs, Article 26. Number 10. Freedom from payment of taxes for promotion of any religion, Article 27. Number 11. Freedom from attending religious instruction or worship in a certain educational institutions. Right to equality. Number 1. Equality before law and equal protection of laws. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision confers rights on all persons, whether citizens or foreigners. Moreover, the word person includes legal persons, that is, statutory corporations, companies, registered societies, or any other type of legal person. The concept of equality before law is of British origin, while the concept of equal protection of law has been taken from the American Constitution. The first concept connotes the absence of any special privileges in favor of any person, the equal subjection of all persons to the ordinary law of the land administered by ordinary law courts, and no person, whether rich or poor, high or low, official or non-official, is above the law. The second concept, on the other hand, connotes the equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws. The similar application of the same laws to all persons who are similarly situated, and the like should be treated alike without any discrimination. Thus, the former is a negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity, and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply, while Article 14 forbids class legislation. It permits reasonable classification of persons, objects, and transactions by the law, but the classification should not be arbitrary, artificial, or evasive. Rather, it should be based on an intelligible, differential, and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law propounded by A.V. Dicey, the British jurist. His concept has the following 3 elements or aspect. Number 1. Absence of arbitrary power, that is, no man can be punished except for a breach of law. Number two, equality before the law, that is, equal subjugation of all citizens, rich or poor, high or low, official or non official, to the ordinary law of the land administered by the ordinary law courts. Number three, the primacy of the rights of the individual, that is, the constitution is the result of the rights of the individual as defined and enforced by the courts of law rather than the constitution being the source of the individual rights. The first and the second elements are applicable to the Indian system and not the third one. In the Indian system, the constitution is the source of the individual rights. The Supreme Court held that the rule of law, as embodied in Article 14, is a basic feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Exceptions to equality. The rule of equality before law is not absolute and there are constitutional and other exceptions to it. These are mentioned below. Number 1. The President of India and the Governor of States enjoy the following immunities under Article 361. First, the President or the Governor is not answerable to any court the exercise and performance of powers and duties of the office. Second, no criminal proceedings shall be instituted or continued and the President or the Governor in any court during his terms of office. Third, no process for the arrest or imprisonment of the President or Governor shall be issued from any court during his term of office. Fourth, no civil proceedings against the President or the Governor to be instituted during his term of office in any court in respect of act done by him in his personal capacity, whether before or after he entered upon his office, until the expiration of 2 months and after notice has been delivered to him. Number 2. No person shall be liable to any civil or criminal proceedings in any court in respect of the publication of in a newspaper or by radio or television of a substantially true report of any proceedings of either House of Parliament or either House of the Legislature of a state under Article 361A. Number 3. No member of parliament shall be liable to any proceedings in any court in respect of anything said or any vote against given by him in parliament or any committee thereof, Article 105. Number 4. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, Article 194. Number 5. Article 31C is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the grounds that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. Number 6. The foreign sovereigns, ambassadors, and diplomats enjoy immunity from criminal and civil proceedings. Number 7. The UNO and its agencies enjoy the diplomatic immunity. Number 2. Prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizens on grounds only of religion, race, caste, sex, or place of birth. The two crucial words in this provision are discrimination and only. The word discrimination means to make an adverse distinction between with regard to or distinguished unfavorably from others. The use of the word only connotes the discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction, or condition on grounds only of religion, race, caste, sex, or place of birth with regard to access to shops, public restaurants, hotels, and places of public entertainment. The use of wells, tanks, bathing ghats, roads, and places of public resort maintained wholly or partly by state funds to the dedicated to the use of general public. This provision prohibits discrimination both by the state and private individuals, while the former provisions prohibits discrimination only by the state. There are 4 exceptions to this general rule of non-discrimination. Number 1. The state is permitted to make any special provisions for women and children, for example, reservation of seats for women in local bodies or provisions of free education for children. Number 2. The state is permitted to make any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled caste and scheduled tribes. For example, reservation of seats or fee concessions in public educational institutions. Number 3. The state is empowered to make any special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes regarding their admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. Number 4. The state is empowered to make any special provisions for the advancement of any economically weaker section of citizens. Further, the state is allowed to make a provision for the reservation of up to 10% of seats for such sections in admission to educational institutions, including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This reservation of up to 10% would be in addition to the existing reservations. For this purpose, the economically weaker section should be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Reservation for OBCs in educational institutions. The above exception was added by the 93rd Amendment Act of 2005. In order to give effect to this provision, the Centre enacted the Central Educational Institutions Reservation in Admission Act 2006, providing a quota of 27% for candidates belonging to the other backward classes in all central higher educational institutions, including the Indian Institute of Technology and the Indian Institute of Management. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act, but the court directed the central government to exclude the creamy layer advanced sections among the OBCs while implementing the law. The children of the following different categories of people belong to creamy layer among OBCs and thus will not get the quota benefit. Number 1. Persons holding constitutional posts like President, Vice President, Judges of Supreme Court and High Court, Chairman and Member of UPSC and SPSC, CEC, CAG and so on. Number 2. Group A, Class 1 and Group B, Class 2 officers of the All India Central and State Services and employees holding equivalent posts in PSUs, banks, insurance organizations, universities, etc. and also in private employment. Number 3. Persons who are in the rank of colonel and above in the army and equivalent post in the navy, the air force and the paramilitary forces. Professionals like doctors, lawyers, engineers, artists, authors, consultants and so on. Number 5. Person engaged in trade, business and industry. Number 6. People holding agricultural land above a certain limit and vacant land or buildings in urban areas. Number 7. Persons having gross annual income of more than rupees 8 lakh or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was rupees 1 lakh. It was subsequently revised to rupees 2.5 lakh in 2004, rupees 4.5 lakh in 2008, rupees 6 lakh in 2013 and rupees 8 lakh in 2017. Reservation for EWS in educational institutions. The above exceptions was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker section in admission to educational institutions. The benefit of this reservation can be availed by the persons belonging to EWS who are not covered under any of the existing schemes of reservations for SC, ST and OBCs. The eligibility criteria laid down in this regard is as follows. Number 1. Persons whose family has gross annual income below rupees 8 lakh are to be identified as EWS for the benefit of reservation. The income would include income from all sources, that is salary, agriculture, business, profession, etc. and it would be income for the financial year prior to the year of application. Number 2. Persons whose family owns or possesses any one of the following assets are to be excluded from being identified as EWS, irrespective of the family income. 5 acres of agricultural land and above, residential flat of 1000 square feet and above, residential plot of 100 square yards and above in notified municipality, residential plot of 200 square yards and above in areas other than the notified municipalities. Number 3. The property held by a family in different locations or different places, cities would be clubbed while applying the land or property holding test to determine EWS status. Number 4. Family for this purpose would include the person who seeks benefit of reservation, his or her parents and siblings belong the age of 18 years and also his or her spouse and children below the age of 18 years. Number 3. Equality of opportunity in public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointed to any office under the state. No citizen can be discriminated against or be ineligible for any employment or office under the state on grounds of only religion, race, caste, sex, descent, place of birth, or residence. There are four exceptions to this general rule of equality of opportunity in public employment. Number one, Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority, as the Public Employment Requirement as to Residence Act of 1957 expired in 1974. There is no such provision for any state except Andhra Pradesh and Telangana. Number two, the state can provide for reservation of appointments or post in favor of any backward class that is not adequately represented in the state services. Number three, a law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to the particular religion or denomination. Number four, the state is permitted to make a provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker section of citizen. This reservation of up to 10% would be in addition to the existing reservation. For this purpose, the economically weaker section should be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Mandal Commission and Aftermath. In 1979, the Morarji Desai government appointed the Second Backward Classes Commission under the chairmanship of B.P. Mandal, a member of parliament, in terms of Article 340 of the Constitution, to investigate the conditions of the socially and economically, educationally backward classes and suggest measures for their advancement. The Commission submitted its report in 1980 and identified as many as 3743 castes as socially and educationally backward classes. They constitute nearly 52% component of the population, excluding the SC/ST. The Commission recommended the reservation of 27% government jobs for the other backward classes so that the total reservation for all SC, ST and OBCs amount to 50%. It was after 10 years in 1990 that the VP Singh government declared reservation of 27% government jobs for the OBCs. Again in 1991, the Narasimha Rao government introduced two changes: preference to the poorer section among the OBCs in 27% quota, that is, adoption of the economic criteria in granting reservation, and reservation of another 10% of jobs for poorer economically backward sections of higher castes who are not covered by any existing schemes of reservation. In the famous Mandal case of 1992, the scope and extent of Article 16.4, which provides for reservation of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. Though the court has rejected the additional reservation of 10% for poorer section of higher castes, it upheld the constitutional validity of 27% reservation for the OBCs with certain conditions. That is, the advanced section among the OBCs, the creamy layer, should be excluded from the list of beneficiary of reservation. This was point number A. Point number B. No reservation in promotions. Reservation should be confined to initial appointments only. Any existing reservation in promotions can continue for 5 years only, that is up to 1997. Point number C. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. Now, point number D. The carry forward rule in case of unfiled backlog vacancies is valid, but it should not violate 50% rule. Point number E. A permanent statutory body should be established to examine complaints of over-inclusion and under-inclusion in the list of OBCs. With regard to the above ruling, the Supreme Court, the government has taken the following actions. Point number A. Ram Nandan Committee was appointed to identify the creamy layer among the OBCs. It submitted its report in 93, which was accepted. Point number B. National Commission for Backward Classes was established in 1993 by an Act of Parliament. Its mandate was to examine the complaints of under-inclusion, over-inclusion or non-inclusion of any class of citizens in the list of backward classes for the purpose of job reservation. Later, the 102nd Amendment Act of 2018 conferred a constitutional status on the Commission and also enlarged its functions. For this purpose, the amendment inserted a new Article 338B in the Constitution. Point number C. In order to nullify the ruling with regard to reservation in promotion, the 77th Amendment Act was enacted in 1995. It added a new provisions in Article 16 that empowers the state to provide for reservation in promotion of any service under the state in favor of the SC and ST and that are not adequately represented in the state services. Again, the 85th Amendment Act of 2001 provides for consequential seniority in the case of promotion or by virtue of rule of reservation for the government servants belonging to the SC and ST with retrospective effect from June 1995. Point number D. The ruling with regard to backlog vacancies was nullified by the 81st Constitutional Amendment Act of 2000. It added another new provisions in Article 16 that empowers the state to consider the unified reserved vacancies of a year as a separate class of vacancies to be filed up in any succeeding year or years. Such class of vacancies are not to be combined with the vacancies of the year in which they are being filed up to determine the ceiling of 50% reservation on total number of vacancies of that year. In brief, it ends the 50% ceiling on reservation in backlog vacancies. Point number E. The 76th Amendment Act of 1994 has placed the Tamil Nadu Reservation Act of 1994 in the 9th schedule to protect it from judicial review as it provided for 69% of reservation far exceeding the 50% ceiling. Reservation for EWS in public employment. The above exception was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker section in civil post and services in the Government of India. The benefit of this reservation can be availed by the persons belonging to the EWS who are not covered under any of the existing schemes of reservation for SC, ST, and OBCs. The eligibility criteria laid down in this regard had already been explained under Article 15. Further, the scientific and technical posts which satisfy all the following conditions can be exempted from the purview of this reservation. First, the post should be in grades above the lower grades in Group A of the service concerned. Second, they should be classified as scientific or technical in terms of Cabinet Secretariat Order 1961, according to which scientific and technical post for which qualifications in the natural sciences or exact sciences or applied sciences or in technology or prescribed and incumbents of which have to use that knowledge in the discharge of their duties. 3. The post should be for conducting research or for gazetting, organizing, guiding, and directing research. Number 4. Abolition of untouchability. Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act 1955 to enlarge the scope and make penal provisions more stringent. The Act defines civil rights as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution or in the Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense, but the practice as it had developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reasons of their birth in certain castes. Hence, it does not cover any social boycott of a few individuals for their exclusion from religion services, etc. The Supreme Court held that the right under Article 17 is available against private individuals and it is the constitutional obligations of the state to take necessary action to ensure that this right is not violated. Number 5. Abolition of titles. Article 18 abolishes titles and makes 4 provisions in that regard. A. It prohibits the state from conferring any title except a military or academic distinction or any body, whether a citizen or a foreigner. B. It prohibits a citizen of India from accepting any title from any foreign state. C. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the president. D. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument or office from or under any foreign state without the consent of the president. From the above, it is clear that the hereditary titles of nobility like Maharaja, Rai Bahadur, Rai Sahib, Diwan Bahadur, etc., which were conferred by colonial states are banned by Article 18 as these are against the principle of equal status of all. In 1996, the Supreme Court upheld the constitutional validity of the national awards Bharat Ratna, Padma Vibhushan, Padma Bhushan, and Padma Shri. It ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only hereditary titles of nobility. Therefore, they are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. However, it also ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. These national awards were instituted in 1954. The Janata Party government headed by Morarji Desai discontinued them in 1977, but they were again revived in 1980 by Indira Gandhi government. Right to freedom. Number 1. Protection of six rights. Article 19 guarantees to all citizens the six rights. These are: first, right to freedom of speech and expression; second, right to assemble peaceably and without arms; third, right to form associations or unions or cooperative societies; fourth, right to move freely throughout the territory of India; fifth, right to reside and settle in any part of the territory of India; sixth, right to practice any profession or to carry on any occupation, trade, or business. Originally, Article 19 contained seven rights, but the right to acquire, hold, and dispose of property was deleted by the 44th Amendment Act of 1978. These six rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company, but not to foreigners or legal persons like companies or corporations, etc. The state can impose reasonable restrictions on the enjoyment of these six rights only on the grounds mentioned in the Article 19 itself and not on any other grounds. Freedom of speech and expression. It implies that every citizen has the right to express his views, opinions, belief, and convictions freely by word of mouth, writing, printing, picturing, or any other manner. The Supreme Court held that the freedom of speech and expression includes the following: first, right to propagate one's views as well as views of others; second, freedom of the press; third, freedom of commercial advertisements; fourth, right against tapping of telephonic conversation; fifth, right to telecast, that is, government has no monopoly on electronic media; sixth, right against bandh called by a political party or organization; seventh, right to know about government activities; eighth, right of freedom of silence; ninth, right against imposition of pre-censorship on a newspaper; 10, right to demonstration or picketing but not right to strike. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Freedom of assembly. Every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstrations, and take out processions. This freedom can be exercised only by public, and the assembly must be peaceful, and unarmed. This provision does not protect violent, disorderly, riotous assemblies, or one that causes breach of public peace, or one that involves arms. This right does not include the right to strike. The state can impose reasonable restrictions on the exercise of right of assembly on two grounds, namely sovereignty and integrity of India and public order, including the maintenance of traffic in the area concerned. Under Section 144 of Criminal Procedure Code 1973, a magistrate can restrain an assembly, meeting, or procession if there is a risk of obstruction, annoyance, or danger to human life, health or safety, or a disturbance of the public tranquility, or a riot, or any affray. Under Section 141 of the Indian Penal Code, an assembly of five or more persons becomes unlawful if the object is to resist the execution of any law or legal process, to forcibly occupy the property of some person, to commit any mischief or criminal trespass, to force some person to do an illegal act, and to threaten the government or the officials on exercising lawful powers. Freedom of association. All citizens have the right to form associations or unions or cooperative societies. It includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions, or any body of persons. if not only includes the right to start an association or union but also to continue with the association or union as such. Further, it covers the negative right of not to form or join an association or union. Reasonable restriction can be imposed on the exercise of this right by the state on the grounds of sovereignty and integrity of India, public order, and morality. Subject to these restrictions, the citizens have complete liberty to form associations or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade unions have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike can be controlled by an appropriate industrial law, freedom of movement. This freedom entitles every citizen to move freely throughout the territory of the country. He can move freely from one state to another or from one place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling, not parochialism. The grounds of imposing reasonable restrictions on this freedom are two, namely the interest of general public and the protection of interest of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. The Supreme Court held that the freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. The Bombay High Court validated the restrictions on the movement of persons affected by AIDS. The freedom of movement has two dimensions, that is, internal, right to move inside the country, and external, right to move out of the country, and right to come back to the country. Article 19 protects only the first dimension. The second dimension is dealt by Article 21, right to life and personal liberty. Freedom of residence. Every citizen has the right to reside and settle in any part of the country, territory of the country. This right has two parts. First, the right to reside in any part of the country, which means to stay at any place temporarily. And second, the right to settle in any part of the country, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism and avoids narrow mindedness. The state can impose reasonable restrictions on the exercise of this right on two grounds, namely the interest of general public and the protection of interest of any scheduled tribes. The right of outsiders to reside and settle in tribal areas is restricted to protect the distinctive culture, language, custom, and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. In many parts of the country, the tribals have been permitted to regulate their property rights in accordance with their customary rules and laws. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. Freedom of profession, etc. All citizens are given the right to practice any profession or to carry on any occupation, trade, or business. This right is very wide as it covers all the means of earning one's livelihood. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to first, prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade, or business. Second, carry on by itself any trade, business, industry, or service, whether to the exclusion, complete or partial, of citizens or otherwise. Thus, no objection can be made when the state carries on a trade, business, industry, or service either as a monopoly, complete or partial, to the exclusion of citizens, all or some only, or in competition with any citizen. The state is not required to justify its monopoly. This right does not include the right to carry on a profession or business or trade or occupation that is immoral, trafficking in women or children, or dangerous harmful drugs or explosives, etc. The state can absolutely prohibit these or regulate them through licensing. Number 2. Protection in respect of conviction for offences. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. It contains three provisions in that direction. First, no ex post facto law. No person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, nor subjected to a penalty greater than the prescribed by the law in force at the time of the commission of the act. Second, no double jeopardy. No person shall be prosecuted and punished for the same offence more than once. Third, no self incrimination. No person accused of any offence shall be compelled to be a witness against himself. An ex post facto law is one that imposes penalties retroactively, that is, upon acts already done or which increases the penalties for such act. The enactment of such a law is prohibited by the first provision of Article 20. However, this limitation is imposed only on criminal laws and not on civil laws or tax laws. In other words, a civil liability or a tax can be imposed retrospectively. Further, this provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. Finally, the protection immunity under this provision cannot be claimed in case of preventive detention or demanding security from a person. The protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. The protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to first, compulsory production of materials object; second, compulsion to give thumb impression, specimen signature, blood specimens; third, compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. Number 3. Protection of life and personal liberty. Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. In the famous Gopalan case of 1950, the Supreme Court has taken a narrow interpretation of the Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive the right to life and personal liberty of a person based on a law. This is because of the expression procedure established by law in Article 21, which is different from the expression due process of law contained in the American Constitution. Hence, the validity of a law that has prescribed a procedure cannot be questioned on the ground that the law is unreasonable, unfair, or unjust. Secondly, the Supreme Court held that the personal liberty means only liberty relating to the person or body of the individual, but in Menka case of 1978, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of the Article 21. Therefore, it ruled that the right to life and personal liberty of a person can be deprived by a law provided the procedures prescribed by that law is reasonable, fair, and just. In other words, it has introduced the American expression due process of law. In effect, the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. Further, the court held that the right to life as embodied in Article 21 is not merely confined to animal existence or survival, but it includes within its ambit the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete, and worth living. It also ruled that the expression personal liberty in Article 21 is of the widest amplitude and it covers a variety of rights that go to constitute the personal liberties of a man. The Supreme Court has reaffirmed its judgment in the Menka case. In the subsequent cases, it has declared the following right as part of Article 21. Number 1. Right to live with human dignity. Number 2. Right to decent environment including pollution-free water and air and protection against hazardous industries. Number 3. Right to livelihood. Number 4. Right to privacy. Number 6. Right to shelter. Number 5. Right to shelter. Number 6. Right to health. Number 7. Right to free education up to 14 years of age. Number 8. Right to free legal aid. Number 9. Right against solitary confinement. Number 10. Right to speedy trial. Number 11. Right against handcuffing. Number 12. Right against inhuman treatment. Number 13. Right against delayed execution. Number 14. Right to travel abroad. Number 15. Right against bonded labor. Number 16. Right against custodial harassment. Number 17. Right to emergency medical aid. 18. Right to timely medical treatment in government hospital. 19. Right not to be driven out of a state. Number 20. Right to fair trial. 21. Right to prisoner to have necessities of life. 22. Right of women to be treated with decency and dignity. 23. Right against public hanging. 24. Right to road in hilly areas. 25. Right to information. 26. Right to reputation. 27. Right to appeal from a judgment of conviction. 28. Right to family pension. 29. Right to social and economic justice and empowerment. 30. Right against bar fetters. 31. Right to appropriate life insurance policy. 32. Right to sleep. 33. Right to freedom from noise pollution. 34. Right to sustainable development. 35. Right to opportunity. Number 4. Right to education. Article 21A declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only such elementary education a fundamental right and not higher or professional education. This provision was added by the 86th Constitutional Amendment Act of 2002. This amendment is a major milestone in the country's aim to achieve education for all. The government described this step as the dawn of the second revolution in the chapter of citizen rights. Even before this amendment, the Constitution contained a provision for free and compulsory education for children under Article 45 in Part 4. However, being a directive principle, it was not enforceable by the courts. Now, there is a scope for judicial intervention in this regard. This amendment changed the subject matter of Article 45 in Directive Principles. It now reads, the state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years. It also added a new fundamental duty under Article 51A that reads, it shall be the duty of every citizen of India to provide opportunity of education to his child or ward between the age of 6 and 14 years. In 1993 itself, the Supreme Court recognized a fundamental right to primary education in the right to life under Article 21. It held that every child or citizen of this country has a right to free education until he completes the age of 14 years. Thereafter, his right to education is subject to the limits of economic capacity and development of the state. In this judgment, the court overruled its earlier judgment 1992, which declared that there was a fundamental right to education up to any level including professional education like medicine and engineering. In pursuance of Article 21A, the Parliament enacted the Right of Children to Free and Compulsory Education Act 2009. This act seeks to provide that every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. This legislation is anchored in the belief that the values of equality, social justice, and democracy and the creation of a just and human society can be achieved only through provision of inclusive elementary education to all. Number 5. Protection against arrest and detention. Article 22 grants protection to persons who are arrested or detained. Detention is of two types, namely punitive and preventive. Punitive detention is to punish a person for an offence committed by him after trial and conviction in a court. Preventive detention, on the other hand, means detention of a person without trial and conviction by a court. Its purpose is not to punish a person for a past offence, but to prevent him from committing an offence in the near future. Thus, preventive detention is only a precautionary measure and based on suspicion. The Article 22 has two parts. The first part deals with the cause of ordinary law, and the second part deals with the cases of preventive detention law. Number 1. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. A. Right to be informed of the grounds of arrest. B. Right to consult and be defended by a legal practitioner. C. Right to be produced before a magistrate within 24 hours including the journey time. D. Right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. The Supreme Court also ruled under that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of a court, civil arrest, arrest on failures to pay the income tax, and deportation of an alien. They apply only to an act of a criminal or quasi criminal nature or some activity prejudicial to public interest. Second, the second part of Article 22 grants protection to persons who are arrested or detained under a preventive detention law. This protection is available to both citizens as well as aliens and includes the following. First, the detention of a person cannot exceed 3 months unless advisory board report sufficient causes for extended definition. The board is to consist of judges of a high court. Second, the grounds of detention should be communicated to the determinants. However, the fact considered to be against the public interest need not to be disclosed. Third, the detainee should be afforded an opportunity to make representation against the detention order. Article 22 also authorizes the Parliament to prescribe the circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. The maximum period for which a person can be detained in any classes of cases under a preventive detention law and the procedure to be followed by an advisory board in an inquiry. The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. However, this provision has not yet been brought into force, hence the original period of 3 months still continues. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislature. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with defense, foreign affairs, and the security of India. Both the Parliament as well as the state legislature can concurrently make a law of preventive detention for reasons connected with the security of a state, the maintenance of public order, and the maintenance of supplies and services essential to the community. The preventive detention laws made by the Parliament are A. Preventive Detention Act 1950, expired in 1969. B. Maintenance of Internal Security Act 1971, repealed in 1978. C. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. D. National Security Act 1980. E. Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act 1980. F. Terrorist and Disruptive Activities Prevention Act 1985, repealed in 1995. G. Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act 1988. H. Prevention of Terrorism Act 2002, repealed in 2004. Unlawful Activities Prevention Act 1967, as amended in 2004, 8, 12, and 19. It is unfortunate to know that no democratic country in the world has made preventive detention as an integral part of the Constitution as has been done in India. It is unknown in USA. It was resorted to in Britain, but only during First and Second World War time. In India, preventive detention existed even during the British rule. For example, the Bengal State Prisoners Regulation of 1818 and the Defence of India Act of 1939 provided for preventive detention. Right against exploitation. Number 1. Prohibition of traffic in human beings and forced labor. Article 23 prohibits traffic in human beings, begar, forced labor, and other similar forms of forced labor. Any contravention of this provision shall be an offence punishable in accordance with law. This right is available to both citizens and non-citizens. It protects the individual not only against the state but also against private persons. The expression traffic in human beings include selling and buying of man, women, and children like goods, immoral traffic in women and children, including prostitution, devadasis, slavery. To punish these acts, the Parliament has made the Immoral Traffic Prevention Act 1956. The term begar means compulsory work without remuneration. It was a peculiar Indian system under which the local jamidars sometimes used to force their tenants to render services without any payment. In addition to begar, the Article 23 prohibits other similar forms of forced labor like bonded labor. The term forced labor means compelling a person to work against his will. The workforce includes not only physical or legal force but also force arising from the compulsion of economic circumstances, that is, working for less than the minimum wage. In this regard, the Bonded Labour System Abolition Act 1976, the Minimum Wages Act 1948, the Contract Labour Act 1970, and the Equal Remuneration Act 1976 were made. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purpose, as for example, military service or social service. for which it is not bound to pay. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste, or class. Number 2. Prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine, or other hazardous activities like construction work or railway, but it does not prohibit their employment in any harmless or innocent work. The Child Labour Prohibition and Regulation Act 1986 is the most important law in this direction. In addition, the Employment of Children Act 1938, the Factories Act 1948, the Mines Act 1952, the Merchant Shipping Act 1958, the Plantation Labour Act 1951, the Motor Transport Workers Act 1951, Apprentices Act 1961, the Beedi and Cigar Workers Act 1966, and other similar acts prohibited the employment of children below certain age. In 1996, the Supreme Court directed the establishment of Child Labour Rehabilitation Welfare Fund, in which the offending employer should deposit a fine of Rs 20,000 for each child employed by him. It also issues directions for the improvement of education, health, and nutrition of children. The Commission for Protection of Child Rights Act 2005 was enacted to provide for the establishment of a National Commission and state commissions for protection of child rights and children's courts for providing speedy trial of offences against children or of violation of child rights. In 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dhabas, restaurants, shops, factories, resort, spas, tea shops, and so on. It warned that anyone employing under children below age 14 years of age would be liable for prosecution and penal action. The Child Labour Prohibition and Regulation Amendment Act 2016 amended the Child Labour Prohibition and Regulation Act 1986. It has renamed the principal act as the Child and Adolescent Labour Prohibition of Regulation Act 1986. Right to freedom of religion. Number 1. Freedom of conscience and free profession, practice, and propagation of religion. Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice, and propagate religion. The implication of these are: A. Freedom of conscience, inner freedom of any individual to mold its relation with God or creatures in whatever way he desires. B. Right to profess, declaration of one's religious beliefs and faith openly and freely. C. Right to practice, performance of religion, worship, rituals, ceremonies, and exhibition of beliefs and ideas. D. Right to propaganda, transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion, but it does not include a right to convert another person to one's own religion. Forcible conversions impinge on the freedom of conscience guaranteed to all the persons alike. From the above, it is clear that Article 25 covers not only religious beliefs, doctrines, but also religious practices, rituals. Moreover, these rights are available to all persons, citizens, as well as non-citizens. However, these rights are subject to public order, morality, health, and other provisions relating to fundamental rights. Further, the state is permitted to: A. Regulate or restrict any economic, financial, political, or other secular activity associated with religious practice. B. Provide for social welfare and reform or throw open Hindu religious institutions of a public character to all classes and section of Hindus. Article 25 also contains two explanations. 1. Wearing and carrying of kirpans is to be included in the profession of the Sikh religion, and 2. The Hindus in this context include Sikh, Jains, and Buddhists. Number 2. Freedom to manage religious affairs. According to Article 26, every religious denomination or any of its section shall have the following rights: A. Right to establish and maintain institutions for religious and charitable purpose. B. Right to manage its own affairs in matters of religion. C. Right to own and acquire movable and immovable property. D. Right to administer such property in accordance with law. Article 25 guarantees rights of individuals, while Article 26 guarantees rights of religious denominations or their sections. In other words, Article 26 protects collective freedom of religion like the rights under Article 25. The rights under Article 26 are also subject to public order, morality, and health, but not subject to other provisions relating to the fundamental rights. The Supreme Court held that a religious denomination must satisfy three conditions: A. It should be a collection of individuals who have a system of beliefs, doctrines, which they regard as conducive to their spiritual well being. B. It should have a common organization. C. It should be designated by a distinctive name. Under the above criteria, the Supreme Court held that the Ramakrishna Mission and Anand Marga are religious denominations within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. Number 3. Freedom from taxation from promotion of a religion. Article 27 lays down that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. In other words, the state should not spend the public money collected by way of tax for the promotion or maintenance of any particular religion. This provision prohibits the state from favoring, patronizing, and supporting one religion over the other. This means that the taxes can be used for the promotion or maintenance of all religions. This provision prohibits only levy of a tax and not a fee. This is because the purpose of a fee is to control secular administration of religious institutions and not to promote or maintain religion. Thus, a fee can be levied on pilgrims to provide them some special service or safety measures. Similarly, a fee can be levied on religious endowments for meeting the regulation expenditure. Number 4. Freedom from attending religious instruction. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of the state funds. However, this provision shall not apply to an educational institution administered by the state but established under any endowment or trust requiring imparting of religious instruction in such institution. Further, no person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to attend any religious instruction or worship in that institution without his consent. In case of a minor, the consent of his guardian is needed. Thus, Article 28 distinguishes between 4 types of educational institutions. A. Institutions wholly maintained by the state. B. Institutions administered by the state but established under any endowment or trust. C. Institutions recognized by the state. Institution receiving aid from the state. D. In a religious instruction is completely prohibited while religious instruction is permitted, and religious instruction is permitted on a voluntary basis. Cultural and educational rights. Number 1. Protection of interest of minorities. Article 29 provides that any section of the citizen residing in any part of India having a distinct language, script or culture of its own shall have the right to conserve the same. Further, no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste or language. The first provision protects the right of a group, while the second provision guarantees the right of a citizen as an individual irrespective of the community to which he belongs. Article 29 grants protection to both religious minorities as well as linguistic minorities. However, the Supreme Court held that the scope of this article is not necessarily restricted to minorities only, as it is commonly assumed to be. This is because of the use of words section of citizens in the article that include minorities as well as majority. The Supreme Court also held that the right to conserve the language includes the right to agitate for the protection of language. Hence, the political speeches or promises made for the conservation of the language of a section of the citizen does not amount to corrupt practice under the Representation of People Act 1951. Number 2. Right of minorities to establish and administer educational institutions. Article 30 grants the following rights to minorities, whether religious or linguistic. First, all minorities shall have the right to establish and administer educational institutions of their choice. Second, the compensation amount fixed by the state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. This provision was added by the 44th Amendment Act of 1978 to protect the right of minorities in this regard. The Act deleted the right to property as a fundamental right under Article 31. Third, in granting aid, the state shall not discriminate against any educational institution managed by a minority. Thus, the protection under Article 30 is confined only to minorities, religious or linguistic, and does not extend to any section of citizens as under Article 29. However, the term minority has not been defined anywhere in the Constitution. The right under Article 30 also includes the right of a minority to impart education to its children in its own language. Minority educational institutions are of three types. A. Institutions that seek recognition as well as aid from the state. B. Institutions that seek only recognition from the state and not aid. C. Institutions that neither seek recognition nor aid from the state. The institution of first and second type are subject to the regulatory power of the state with regard to syllabus prescription, academic standards, discipline, sanitation, employment of teaching staff, and so on. The institutions of third type are free to administer their affairs but subject to operation of general laws like contract law, labor law, industrial law, tax law, economic regulation, and so on. In a judgment delivered in the Secretary of Malankara Syrian Catholic College case of 2007, the Supreme Court has summarized the general principles relating to the establishment and administration of minority educational institution in the following way. First, the number one, the right of minorities to establish and administer educational institutions to their choice comprises the following rights. First, to choose its governing body in whom the founders of institutions have faith and confidence to conduct and manage affairs to the institution. Second, to appoint teaching staff, teachers, lecturers, and headmasters, principals, and also non-teaching staff, and to take according if there is a dereliction of duty on any part of its employees. Third, to admit eligible students of their choice and to set up reasonable fee structure. Fourth, to use its properties and assets for the benefit of the institution. Number 2. The right conferred on minorities under Article 30 is only to ensure equality with the majority and not intended to place the minorities in a more advantageous position that is the majority. There is no reverse discrimination in favor of minorities. The general laws of the land relating to national interest, national security, social welfare, public order, morality, health, sanitation, taxation, etc. applicable to all will equally apply to minority institutions also. Number 3. The right to establish and administer educational institutions is not absolute, nor does it include the right to maladminister. There can be regulatory measures for ensuring educational character and standards and maintaining academic excellence. There can be checks on administration as are necessary to ensure that the administration is efficient and sound so as to serve the academic needs of the institution. Regulations made by the state concerning generally the welfare of students and teachers, regulations laying down eligibility criteria and qualifications for appointments as also conditions of service for employees, both teaching and non-teaching, regulations to prevent exploitation or oppression of employees, and regulations prescribing syllabus and curriculum of study fall under this category. Such regulations do not in any manner interface with the right under Article 30 Clause 1. Number 4. Subject to the eligibility conditions, qualifications prescribed by the state being met, the unaided minority educational institutions will have the freedom to appoint teachers, lecturers by adopting any rational procedure of selection. Number 5. Extension of aid by the state does not alter the nature and character of the minority educational institutions. The conditions can be imposed by the state to ensure proper utilization of the aid without, however, diluting or abridging the right under Article 30, Clause 1. Right to constitutional remedies. A more declaration of fundamental right in the Constitution is meaningless, useless, and worthless without providing an effective machinery for their enforcement, and if and when they are violated. Hence, Article 32 confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. In other words, the right to get the fundamental right protected is in itself a fundamental right. This makes the fundamental rights real. That is why Dr. Ambedkar called Article 32 as the most important article of the Constitution, an article without which the Constitution would be a nullity. It is the very soul of the Constitution and the very heart of it. The Supreme Court has ruled that Article 32 is a basic feature of the Constitution. Hence, it cannot be abridged or taken away even by way of an amendment to the Constitution. It contains the following 4 provisions. First, the right to move the Supreme Court by appropriate proceedings for the enforcement of the fundamental right is guaranteed. Second, the Supreme Court shall have power to issue directions or orders or writs for the enforcement of any of the fundamental rights. The writs issued may include habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Third, Parliament can empower any other court to issue directions, orders, and writs of all kinds. However, this can be done without prejudice to the above powers conferred on the Supreme Court. Any other court here does not include High Courts because Article 226 has already conferred these powers on the High Courts. Fourth, the right to move the Supreme Court shall not be suspended except as otherwise provided for by the Constitution. Thus, the Constitution provides that the President can suspend the right to move any court for the enforcement of the fundamental rights during a national emergency under Article 359. It is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental rights of the citizens. It has been vested with the original and wide powers for that purpose. Original because an aggrieved citizen can directly go to the Supreme Court, not necessarily by way of appeal. Wide because its power is not restricted to issuing of orders or directions but also writs of all kinds. The purpose of Article 32 is to provide a guaranteed, effective, expeditious, inexpensive, and summary ready remedy for the protection of the fundamental rights. Only the fundamental rights guaranteed by the Constitution can be enforced under Article 32 and not any other right like non-fundamental constitutional rights, statutory rights, customary rights, and so on. The violation of a fundamental right is the sine qua non for the exercise of the right conferred by Article 32. In other words, the Supreme Court under Article 32 cannot determine a question that does not involve fundamental rights. Article 32 cannot be invoked simply to determine the constitutionality of an executive order or a legislation unless it directly infringes any of the fundamental rights. In case of the enforcement of fundamental rights, the jurisdiction of the Supreme Court is original but not exclusive. It is concurrent with the jurisdiction of the High Court under Article 226. It vests original powers in the High Court to issue directions, orders, and writs of all kinds for the enforcement of the fundamental rights. It means when the fundamental rights of a citizen are violated, the aggrieved party has the option of moving either the High Court or the Supreme Court or the Supreme Court directly. Since the right guaranteed by Article 32, that is the right to move the Supreme Court where a fundamental right is infringed, is in itself a fundamental right, the availability of alternate remedy is no bar to relief under Article 32. However, the Supreme Court has ruled that where relief through High Court is available under Article 226, the aggrieved party should first move the High Court. Writs, types and scope. The Supreme Court under Article 32 and the High Courts under Article 226 can issue the writs of habeas corpus, mandamus, prohibition, certiorari, and quo warranto. Further, the Parliament under Article 32 can empower any other court to issue these writs. Since no such provisions has been made so far, only the Supreme Court and the High Courts can issue the writs and not any other court. Before 1950, only the High Courts of Calcutta, Bombay and Madras had the power to issue the writs. Article 226 now empowers all the High Courts to issue the writs. These writs are borrowed from English law where they are known as prerogative writs. They are so called in England as they were issued in the exercise of the prerogative of the king who was and is still described as the fountain of justice. Later, the High Court started issuing these writs as extraordinary remedies to uphold the rights and liberties of the British people. The writ jurisdiction of the Supreme Court differs from that of a High Court in three respects. Number 1. The Supreme Court can issue writs only for the enforcement of fundamental rights, whereas a High Court can issue writs not only for the enforcement of fundamental rights but also for any other purpose. The expression for any other purpose refers to the enforcement of an ordinary legal right. Thus, the writ jurisdiction of the Supreme Court in this respect is narrower than that of High Court. Number 2. The Supreme Court can issue writs against a person or government throughout the territory of India, whereas a High Court can issue writs against a person residing or against a government or authority located within its territorial jurisdiction only or outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdiction. Thus, the territorial jurisdiction of the Supreme Court for the purpose of issuing writs is wider than that of a High Court. Number 3. A remedy under Article 32 is in itself a fundamental right and hence the Supreme Court may not refuse to exercise its writ jurisdiction. On the other hand, a remedy under Article 226 is discretionary and hence a High Court may refuse to exercise its writ jurisdiction. Article 32 does not merely confer powers on the Supreme Court, as Article 226 does on a High Court to issue writs for the enforcement of fundamental rights or other rights as part of its general jurisdiction. The Supreme Court is thus constituted as a defender and guarantor of the fundamental rights. Now, we will proceed to understand the meaning and scope of different kinds of writs mentioned in Article 32 and 226 of the Constitution. Habeas corpus. It is a Latin term which literally means to have the body of. It is an order which issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of detention. It would set the detained person free if the detention is found to be illegal. Thus, this writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the detention is lawful, the proceeding is for contempt of a legislature of a court, detention is by a competent court, and detention is outside the jurisdiction of the court. Mandamus. It literally means we command. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be used against any public body, a corporation, an inferior court, a tribunal, or government for the same purpose. The writ of mandamus cannot be issued against a private individual or body to enforce departmental instruction that does not possess statutory force when the duty is discretionary and not mandatory, to enforce a contractual obligation against the President of India or the state governors, against the Chief Justice of a High Court acting in judicial capacity. Prohibition. Literally, it means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus, that directly activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not only available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari. In the literal sense, it means to be certified or to be informed. It is issued by a higher court to a lower court or tribunal, either to transfer a case pending with the latter to itself or to request the order of the latter in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. Thus, unlike prohibition, which is unlikely preventive, certiorari is both preventive as well as curative. Previously, the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting rights of individuals. Like prohibition, certiorari is also not available against legislative bodies and private individuals or bodies. Quo warranto. In the literal sense, it means by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. The writ can be issued only in case of a substantive public office by a permanent character created by a statute or by constitution. It cannot be issued in cases of ministerial office or private office. Unlike the other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. Armed forces and fundamental rights. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies, and analogous force. The objective of this provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on the Parliament and not on state legislatures. Any such law made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Accordingly, the Parliament has enacted the Army Act 1950, the Navy Act 1950, the Air Force Act 1950, the Police Forces Restriction of Rights Act 1966, the Border Security Force Act, and so on. These impose restrictions on their freedom of speech, right to form associations, right to be members of trade unions or political associations, right to communicate with the press, right to attend public meetings or demonstrations, etc. Martial law versus national emergency. Martial law. Martial law affects only fundamental rights, while national emergency affects not only fundamental right but also center state relations, distribution of revenues, and legislative powers between center and state, and may extend the tenure of the parliament. This was point number one. Point number two. Martial law suspends the government and ordinary law courts, while national emergency continues the government and ordinary law courts. Point number three. It is imposed to martial law is imposed to restore the breakdown of law and order due to any reason, while national emergency can be imposed only on three grounds: war, external aggression, or armed rebellion. Point number 4. Martial law is imposed in some specific areas of the country, while national emergency is imposed either in the whole country or in any part of it. Martial law. Point number 5. Martial law has no specific provision in the constitution, it is implicit, while national emergency has a specific and detailed provision in the constitution, it is explicit in nature. The expression members of the armed forces also covers such employees of the armed forces as barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors who are non-combatants. A parliamentary law enacted under Article 33 can also exclude the court martial tribunals established under the military law from the writ jurisdiction of the Supreme Court and the High Courts so far as the enforcement of fundamental right is concerned. Martial law and fundamental rights. Article 34 provides for the restriction on fundamental rights while martial law is in force in any area within the territory of India. It empowers the Parliament to indemnify any government servants or other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law was in force. The Parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered, or other act done under martial law in such area. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental right. The concept of martial law has been borrowed in India from the English common law. However, the expression martial law has not been defined anywhere in the Constitution. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed by outside the ordinary law. It does imply the suspension of ordinary law and the government by military tribunals. It is different from the military law that is applicable to the armed forces. There is also no specific or express provision in the Constitution that authorizes the executive to declare martial law. However, it is implicit in Article 34, under which martial law can be declared in any area within the territory of India. The martial law is imposed under the extraordinary circumstances like war, invasion, insurrection, rebellion, riot, or any violent resistance to law. Its justification is to repeal force by force for maintaining or restoring order in the society. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of the civilians, can punish the civilians, and even condemn them to death. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. The declaration of a martial law under Article 34 is different from the declaration of a national emergency under Article 352. The difference between the two are summarized below. Affecting certain fundamental rights. Article 35 lays down that the power to make laws to give effect to certain specified fundamental right shall vest only in the Parliament and not in the state legislatures. This provision ensures that there is uniformity throughout India with regard to the nature of those fundamental rights and punishment for their infringement. In this direction, Article 35 contains the following provisions. Number 1. The Parliament shall have and the legislature of a state shall not have power to make laws with respect to the following matters. A. Prescribing residences as a condition for certain employments or appointments in a state or union territory or local authority or other authority under Article 16. B. Empowering courts other than the Supreme Court and the High Courts to issue directions, orders, and writs of all kinds for the enforcement of fundamental rights under Article 32. C. Restricting or abrogating the application of fundamental rights to members of armed forces, police forces, etc. under Article 33. D. Indemnifying any government servant or any other person for any act done during the operation of martial law in any area under Article 34. Point number 2. Parliament shall have and the legislature of a state shall not have powers to make laws for prescribing punishment for those acts that are declared to be offences under the fundamental right. These include the following: A. Untouchability under Article 17. B. Traffic in human beings and forced labour under Article 23. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishments for the above Act, thus making it obligatory on the part of the Parliament to enact such laws. Point number 3. Any law in force at the commencement of the Constitution with respect to any of the matters specified above is to continue in force until altered or repealed or amended by the Parliament. It should be noted that Article 35 extends the competence of the Parliament to make a law on the matters specified above, even though some of those matters may fall within the spheres of the state legislature, that is, the state list. Present position of right to property. Originally, the right to property was one of the 7 fundamental rights under Part 3 of the Constitution. It was dealt by Article 19, Clause 1, subsection F, and Article 31. Article 19(1)(f) guaranteed to every citizen the right to acquire, hold, and dispose of property. Article 31, on the other hand, guaranteed to every person, whether citizen or non-citizen, right against deprivation of his property. It provided that no person shall be deprived of his property except by authority of law. It empowered the states to acquire or requisition of the property of a person on 2 conditions. It should be for public purpose and it should provide for payment of compensation to the owner. Since the commencement of the Constitution, the fundamental rights to property has been the most controversial. It has caused confrontations between the Supreme Court and the Parliament. It has led to a number of constitutional amendments, that is 1st, 4th, 7th, 25th, 39th, 40th and 42nd amendments. Through these amendments, Article 31A, 31B and 31C have been added and modified from time to time to nullify the effect of Supreme Court judgments and to protect certain laws from being challenged on the grounds of contravention of fundamental rights. Most of the litigation centered around the obligation of the state to pay compensation for acquisition or requisition of private property. Therefore, the 44th Amendment Act of 1978 abolished the right to property as a fundamental right by repealing Article 19(1)(f) and Article 31 from Part 3rd. Instead, the Act inserted a new Article 300A in Part 12 under the heading Right to Property. It provides that no person shall be deprived of his property except by authority of law. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. The right to property as a legal right, as distinct from the fundamental right, has the following implications. A. It can be regulated, that is, curtailed, abridged, or modified without constitutional amendment by an ordinary law of the Parliament. B. It protects private property against executive action but not against legislative action. C. In case of violation, the aggrieved person cannot directly move the Supreme Court under Article 32, right to constitutional remedies including writs for its enforcement. He can move the High Court under Article 226. D. No guaranteed right to compensation in case of acquisition or requisition of the private property by the state. Though the fundamental right to property under Part 3rd has been abolished, the Part 3rd still carries 2 provisions which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. These 2 cases where compensation has to be paid are: case number 1, when the state acquires the property of a minority educational institution under Article 30. Case number 2, when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limits under Article 31A. The first provision was added by the 44th Amendment Act 1978, while the second provision was added by the 17th Amendment Act 1964. Further, Article 31A, 31B and 31C have been retained as exceptions to the fundamental right. Exceptions to fundamental right. Number 1. Saving of laws providing for acquisition of estates, etc. Article 31A saves 5 categories of laws from being challenged and invalidated on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, and Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. They are related to agricultural land, reforms, industry, and commerce and include the following: A. Acquisition of estates and related rights by the state. B. taking over the management on properties by the state. C. Amalgamation of corporations. D. Extinguishment or modifications of right of directors or shareholders of corporations. E. Extinguishment or modification of mining leases. Article 31A does not immunize a state law from judicial review unless it has been reserved for the President's consideration and has received his assent. This article also provides for the payment of compensation at market value when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limit. Number 2. Validation of certain acts and regulation. Article 31B saves the act and regulations included in the ninth schedule from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Thus, the scope of Article 31B is wider than Article 31A. Article 31B immunizes any law included in the ninth schedule from all the fundamental rights, whether or not the law falls under any of the five categories specified in Article 31A. However, in a significant judgment delivered in IR Colo case 2007, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the ninth schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the ninth schedule. It said that the laws placed under the ninth schedule after April 24, 1973 are open to challenge in court if they violated fundamental rights guaranteed under Article 14, 15, 19 and 21 or the basic structure of the Constitution. It was on April 24, 1973 that the Supreme Court first propounded the doctrine of basic structure or basic feature of the Constitution in its landmark verdict in the Keshwanand Bharti case. Originally, in 1951, the ninth schedule contained only 13 acts and regulations, but at present, in 2016, their number is 282. Of these, the act and regulations of the state legislature deal with land reforms and abolition of the jamidari system, and that of the parliament deal with other matters. Number 3. Saving of laws giving effect to certain directive principles. Article 31C, as inserted by the 25th Amendment Act of 1971, contained the following two provisions. A. No law that seeks to implement the socialistic directive principles specified in Article 39B or C shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, or Article 19, protection of six rights in respect of speech, assembly, movement, etc. B. No law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Keshwanand Bharti case, 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. The 42nd Amendment Act 1976 extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles specified in Part 4 of the Constitution and not merely in Article 39B or C. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills case of 1980. Criticism of fundamental rights. The fundamental right enshrined in Part 3 of the Constitution have met with a wide and varied criticism. The arguments of the critics are: Number 1. Excessive limitations. They are subjected to innumerable exceptions, restrictions, qualifications, and explanations. Hence, the critics remarked that the Constitution grants fundamental rights with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental rights should be renamed as Limitations on Fundamental Rights or Fundamental Rights and Limitations Thereon. Number 2. No social and economic rights. The list is not comprehensive as it is mainly consists of political rights. It makes no provision for important social and economic rights like right to social security, right to work, right to employment, right to rest and leisure, and so on. These rights are made available to the citizens of advanced democratic countries. Also, the socialistic constitutions of erstwhile USSR or China provided for such rights. Number 3. No clarity. They are stated in a vague, indefinite, and ambiguous manner. The various phrases and words used in the chapter, like public order, minorities, reasonable restriction, public interest, and so on, are not clearly defined. The language used to describe them is very complicated and beyond the comprehension of the common man. It is alleged that the constitution was made by the lawyers for the lawyers. Sir Ivor Jennings called the Constitution of India a paradise of lawyers. Number 4, no permanency. They are not sacrosanct or immutable as the parliament can curtail or abolish them, as for example, the abolition of the fundamental right to property in 1978. Hence, they can become a play tool in the hands of politicians having majority support in the parliament. The judicially innovated doctrine of basic structure is the only limitation on the authority of parliament to curtail or abolish the fundamental right. Number 5, suspension during emergency. The suspension of their enforcement during the operation of national emergency, except Article 20 and 21, is another blot on the efficacy of these rights. This provision cuts at the roots of democratic system in the country by placing the rights of the millions of innocent people in continuous jeopardy. According to the critics, the fundamental rights should be enjoyable in all situations, emergency or no emergency. Number 6, expensive remedy. The judiciary has been made responsible for defending and protecting these rights against the interference of the legislature and executives. However, the judicial process is too expensive and hinders the common man from getting his rights enforced through the courts. Hence, the critics say that the rights benefit mainly the rich section of the Indian society. Number 7, preventive detention. The critics assert that the provision for preventive detention, Article 22, takes away the spirit and substance of the chapter on fundamental rights. It confers arbitrary powers on the state and negates individual liberty. It justifies the criticism that the Constitution of India deals more with the rights of the state against the individual than with the right of the individual against the state. Notably, no democratic country in the world has made preventive detention as an integral part of their constitutions as has been made in India. Number 8, no consistent philosophy. According to some critics, the chapter on fundamental rights is not the product of any philosophical principle. Sir Ivor Jennings expressed this view when he said that the fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. The critics say that this creates difficulty for the Supreme Court and the High Courts in interpreting the fundamental rights. Significance of fundamental rights. In spite of our criticism and shortcomings, the fundamental rights are significant in the following respect. They constitute, number 1, they constitute the bedrock of democratic system in the country. Number 2, they provide necessary conditions for the material and moral protection of men. Number 3, they serve as a formidable bulwark of individual liberty. Number 4, they facilitate the establishment of rule of law in the country. Number 5, they protect the interest of minorities and weaker section of society. Number 6, they strengthen the secular fabric of the Indian state. Number 7, they check the absoluteness of the authority of the government. Number 8, they lay down the foundation stone of social equality and social justice. Number 9, they ensure the dignity and respect of individuals. Number 10, they facilitate the participation of people in the political and administrative process. Rights outside Part 3rd. Besides the fundamental right included in Part 3rd, there are certain other rights contained in other parts of the Constitution. These rights are known as constitutional rights or legal rights or non-fundamental rights. They are, number 1, no tax shall be levied or collected except by authority of law, Article 265 in Part 12th. Number 2, no person shall be deprived of his property saved by the authority of the law, Article 300A in Part 12th. Number 3, trade, commerce and intercourse throughout the territory of India shall be free, Article 301 in Part 13. Even though the above rights are also equally justiciable, they are different from the fundamental right. In case of violation of a fundamental right, the aggrieved person can directly move the Supreme Court for its enforcement under Article 32, which is in itself a fundamental right. But in case of violation of the above rights, the aggrieved person cannot avail this constitutional remedy. He can move the High Court by an ordinary suit or under Article 226 writ jurisdiction of High Court. The theoretical part of this chapter ended here, but you can refer table of this chapter, which is articles related to fundamental right at a glance. You can find this table in M.Laxmikant book chapter number 7 or online PDFs. Thank you so much.